You lost it. My lord, item number 6, you lost it. May kindly be adjourned, you lost it. Right? Because of the fact that you lost it. We did not it, we still it at the disposal of the junior. Paper book has not been made, I think. 302, madam. 302. 302. Are you filing objection? You can file objection. Would you file? Okay, right. Mr. A. Dewan. And A. Dewan doesn't talk for the police state for again. Item 6. Item 6. Yeah, right. As paper book has, no, as PTR has right. Registry to prepare the paper book. That is the IA, right? You is granted 4 weeks time to file. The application for public, the public. Listing, IF for failed. When? When do you want? Huh? Next week. That is all. In fact, but it's he against conviction, madam. It's already filed, madam. Maybe taken up in the next week. Yes. It's no question. It was last posted on 30. When do you want? When do you want it? Where, huh? Next. Yes. Election for listing, huh? One IA for bill. But maybe district open to okay. Item number 20. Item number 20. Yes. 12th November. Yeah, for the? I'm on the behalf of my senior BKC for the respondent. Have you taken the consent of the other side? You taken the consent. What is your name, madam? Deepegu. Ms. Deepegu. Learned counsel appearing on behalf of Mr. P.K. Singh, learned counsel for the respondent. Pays for adjournment and submits that he has taken the consent of the other. 20. Accordingly, release this matter on 12th November. 3rd November. Achieve the consent of others and documentation item number 2. The conducting council achieves outdoor station. We have already informed others. Okay, right. A general prayer has been made on behalf of Mr. BP Bora. BP Bora. Council for the yesterday. As a German slip has already been publicly. This is the matter. When? After 4 weeks. After 4 weeks. Much. It is also noticed that the PCR has not arrived. This is a matter of the 4 weeks. Not. So far, from 6 days. Financial year, the first page is here. I just wanted a sample form. We didn't want. Anyway, now what to do? What's it for our issue notice with the XCC here? Because what's it the CSET is allowed there actually on the 2 ground. First ground that what cannot be passed on the basis of 126 years. And second, there is a question of limitation of also taken into consideration. Okay, right. Right with the XCC. Yeah, but then this does not take away the fact that even though the because it's not being a button to your service of demand under the basic care, that does not take away the fact that we have got to prove that also. No, that has been taken into consideration by the existing first of lecture. in the discuss in detail, sir. Right. Okay, this aspect of the matter is not been taken consideration by any of the high court. What? Regarding section 26A, 126A. Only some private knowledge first order against the company, but you cannot make assessment on the basis of 126A. No, no. There the issue is different. So out is whether the tax authority can confirm a service tax demand on the basis based on the 26A. Yes, sir. In the absence of a rebuttal. No. That is the issue. Yes. Basically, that is the issue. Another question of the limitation period is also there because we have informed the extended period of limitation because they didn't file because the service didn't file what? What if they didn't file the SC3 disclosing their contract value? What? Did they file the? They have not filed return under section ST3. ST3. Yes. So that's why extended period of limitation is imposed by the department under section 73 of the service. Actually, consider but that is not your suggested. It is there. That is not there. Yes. Question number 2. No. Okay. Take putting option. Okay, right. Third mistake is there. Talk to party. Objection of PGSP and etc. The present appeal makes a challenge to the final order. Number 751/77/2024. Dated 8/2/2024, passed by the Honorable Secretary, Kolkata. Kolkata. CES. The question that are involved to be decided is whether the tax authority can raise and confirm a service tax demand solely on the basis of the entries in Form 26A issued by the Income Tax Department, which has not been rebutted. Correct? Yes. Which has not been rebutted by the FF. No. So the choke-on notice was issued by you after the extended period. No, after the period of limitation. Booking the extended period of period. So that the SESTAT held that it was not permissible. SESTAT is not permissible. Number 2, whether the SESTAT Kolkata was right in holding that the investigation and the consequential show-cause notice issued to the SSC was not permissible by invoking the extended period of limitation under section 73 of Service Act, Finance Act 1994 of the Finance Act 1994. Finance Act 1994. That's all. No. Issue notice returnable in 4 weeks. No. Appellant take step for notice for the respondent by speed post. No. Within a period of by Monday, by Wednesday, because Monday till this close. By Wednesday, a period of 6 days. No. This is a matter of the court. Not so. Not so. I was under 14 rule 5 for stay of the think you pick up one with that. Yes, in the eye, right? Uh, no, no, in the main thing, right? If you notice on the eye answer. Uh, Right, next, sir. Let's say I'm going to counsel for the apparent who submits that the apparent has been convicted under section 6 of the POCSO Act by judgment dated 30/11/24, passed by the Court of the Additional Section Judge, some special judge POCSO, Kamruk and Guwahati, in section bracket special case number 219/2023, arising out of cutting down case number 257 of 2020. If you notice, admit the appeal, call for the CCR. If you notice, Honorable Kovic will be where the additional CCR notice on the appeal. The appellant shall submit a copy of the appeal to the office of the people, who can thereafter furnish the same to the concerned, the OC of the concerned police chief. No, no, this is a new case. Where is that? Oh, there's an IA. What is the IA? IA for suspending. I first that was. No, no, IA. IA also there's no order. What IA? I know. These two problems. Which IA? Delay. Delay IA. Let us see the delay IA. It is different. Out here, no notice of it. Yeah. Notice has been given. What about that? Okay. No, no, cut that. Issue notice, close the issue notice, just say, cut that issue notice, right? Just say, with the lead you have, with, no, with, you have, additional things, appear for you. As can be seen from the order dated 3925 passed in the disposal of IA criminal 65 of section. Notice has been served upon the informant. According no such notice is served in the present. It is a matter of the court. Who final objection? That is the IA, right? The people here, additional people granted for which time to file an objection to the application under section 4 I fully 1021 for suspension of control. The final reform like it. That's item number 4, like 2 months leave, these new agents it's not. So we'll be finding out a couple of months base and making the color. Previous in there. Mr. Ambiswas. Ambiswas. He will be appearing for Atapur Raman. What? Atapur Raman, I have a training for the year I know, but I will get not to the. What about in item 6, item 5? I don't even have the pay. You have the paper book. No paper book. Huh? Paper book? Not required, I think. Paper book is made for not the same. Madam, you have received paper book. You take it from the earlier council. You have received. Miss, what is your name? My king number for not sick. Only state of Assam is being related to India. Oh, no, but then all the paper book is all state of Assam. Yes, no, you know, find the state of Assam, but the letter because of the change. Item was made for every year of India. And secondly, item 4, when the response number 2, who died long back, they didn't make a party. That corrections were made. What does the improved judgment say? DRI or Sridhar? It's a DRI. Yeah. Okay. I see. So who had made the appeal? You all must have made it in your appeal petition. No, no, we have written for right. Yeah. I can file it, there is no problem. For appeal petition, they have said Sridhar. Yes. So corrected as per the email. Okay, right. Miss S. I. Chopin. A. K. Chopin. Chopin. Copy. Chopin. Submit that he and her senior, Mr. M. Sir, will be appearing for the appellant, MB Attapur Raman, in criminal appeal 401/2020, and accordingly paid for adjournment, as they had been engaged only yesterday. He submits that Bakarat Tampa will be filed within a week. Pushkar. Mr. N.J. Datta submits that he is appearing for the, before that, Mr. A.K. Topic further submits that paper book has been displayed by has been displayed. Mr. N.J. Datta left counsel for the appellate in criminal appeals 358 of 2020. He submits that he has not received a copy of the paper. Next para, Mr. M.K. Boro, counsel for the DRI, submits that paper book has not been received by him also. Correct. Number 5, Mr. S.C. Cal, appearing for the respondent, which respondent? The DRI. For the DRI. Yeah. In criminal appeal 358 of 2023, submits that he has received, not received. He has not received a copy of the paper. Madam, you're not there, no? Then you give it to them. Then you give it to them. Ah, you give it to them. I have received. Okay. It's the ethic, like for DRI, it's huh? If I will the I think that they have received a copy of the paper book. Oh, Miss people, yeah. Additional PP content. We also submit that the state of Assam is not a party in this case. In as much as the enforcement agency in the present two cases is the DR. Criminal appeal 401 of 2020. Yeah. Registry to provide copies of the paper to Mr. NJ Data and Mr. NK Board. Also for the DRI is criminal appeal 401 of 2020. This is the matter after 3 weeks. Registry to also strike out the name of Ms. B. Buyan. Addition, may strike out strike of PPSR from the cause list and instead put the name of SCDRI. SCDRI in the cause. Uttam. Consequently, no, next paragraph. As the mistake in the first title appears to have made due to the fault of the appellate in criminal appeal 401 of 2023. The appellant in 401 of 2023 shall submit a fresh copy of the past title showing DRI instead of the state of affairs as the respondent number one. As the respondent, as the respondent. That's all. Probably. The necessary corrections should thereafter be made in the report. The report in the file, file cover, file cover in the report, in the. Significant lordship.
In my lordship, they have filed the respondents have entered their appearance. What are the respondents? What are they entered their appearance?
Can we hear it or will we need paper book? What is it?
But it will be necessary because the next item, lordship, mm, in this case, lordship, there were six accused persons. Two of them were acquitted and two of them were convicted. The next item is the appeal of the convicted person.
Honorated.
Yes. Item number 8. Yeah, correct.
Mr.
The court book will be necessary.
Mr.
A. Ganguly.
I. Ganguly appears for appellate in criminal appeal 19127. We submit that the police appeal is a challenge to be acquitted of how many of them? Six.
Six.
Six accused out of 8.
4 have been acquitted out of 6.
Yeah, 2 is 4 out of 2. Are you, whatever I said. Last sentence. Is a challenge to the acquittal of 4 accused. Is out of 6 accused. On the other hand, Mr. Y.S. Gonna
But in my case, we have also filed 9.
appeals for the 2 accused persons who have been convicted with fire and Section 302. As PCR has arrived, they just need to declare the case. Okay, then the IA there is they have filed their open objection on the final objection final. Fine. Yes. You have to hear it. Not it will also go to hear it. I don't know where it is. Where is that?
Basically, you're also one from I number 381.
No, who is for the acquitted person? Notice has been issued.
Item numbers as per the last 6 month minor steps yet to be taken.
I think 7 they have entered the appearance, but I cannot been filed it. It shows that just the number 2, 3, 4, and 5 have here. I think they are appearing.
Okay. 2, 3, 4, 5. Huh? Okay, right. No one appears, huh? That's particular. No one appears for the respondents number 2, 3, 4, and 5. Even though office note indicates that.
She appears here.
Which F. Hussain appears for the respondents number 2, 3, and 4 in criminal appeal 191 of 2020. However, no one appears for the respondent number 5, even though Wakalatnama has been filed by a counsel correspondent. Then, so that is the main thing. Huh? Now in the IA, yes, you have to hear.
The I this the conviction in this matter is for life and for life. And fine of 20,
That is for the 2 appeals. Okay, the 2 appeals that is one order. Now, IA will be separate.
I is 3-1. 383. In this matter, your lordship, basically the conviction is of life on the basis of dying. The whole case was on the basis of a dying declaration by the person deceased. Now, my ground will be, since this is the I will not go into the depth of the whole matter in the marriage, but on the basis of the points. Now, the dying declaration was not made as part things because it has to be made before a minister, but that was not done. The police have also not recorded the dying. The dying declaration,
Supposing there's no time to go to the fix. There's no time
that
to
is
go.
what I'm trying to point. I'll come to that. There are 3 persons who are sons of the deceased and one another person have recorded in their evidence that the person concerned had given a dying declaration to them at a particular different point of time. That is, these are the issues. Now, I have my issue is that these three persons to whom the dying declaration has been said to be have given is also not consistent with each other. Number one. Number two, your lordship comes to fact that dying declaration. What is exactly a dying declaration? I'll come to the judgments and other things. The dying declaration is a declaration made by a person at the point just before his death when the person finds that he's nearly ending his life. Now, here the question is the person dies after about a month from the uh, incident. After about a month, about 29, 28, 29 days from the date of the incident. One of the PW, your point is very important. That is what. First, one of the PW1 said he was not conscious for 4 5 days. After 4 5 days, he gives a dying. Then the other PW who says the dying declaration was before him, he also, your lordship, mentions that the dying declaration was given on the day when the incident happened. That means he was conscious at that point of time. So these, there is some. Uh, then third person says that the dying declaration was given on a particular day when he was absolutely all right to give a dying declaration. That is another person. That is not the son of the deceased. So these are the three dying declarations they say. Now my question, first question will be whether these declarations which were stated to have been dying declarations are actually a dying declaration or just a statement made in an evidence on the basis of the person concerned. That may be the point ground number one, because what is a dying declaration? Philosophy. Now, the other point is that these three dying persons who has given evidence at PW 1, 2, and 7, they have stated some different, though the names of these persons were stated in a different way. Time were different, dates were different. Somebody says somebody came and these two persons' name have been taken. In another case, all the 6 persons' name has been taken. In another dying declaration, names were not taken, but he says that so and so sons have attacked me. This is the whole issue. I'm not taking your logic to the evidences because they are in ASLI. One or two evidences are only in. I can read the.
Have you filed an objective? Yes, 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 sir.
Fine, but the reason is that I can go to
Skills concern looking for the but I also need to file an objection. But I'm the informant in this case. Where is the procedure? Which perspective? Which are that is just about. You can only assist. Yes, sir. Only if you can assist. That's all. You cannot take the role of the main particular. Go beyond your brief.
Then you,
Just thinking in the line we are going to go.
yes,
I think we'll have to go into the evidence also.
yes, because basically, I think at least PW 2, 4, and 7 are be gone into because they are the ones who said that
It basically amount to hearing the entire thing.
to consider that thing.
So we'll hear the entire. I think we'll let
That can also be done.
otherwise it'll be.
Yes, yes, I
we'll
also
be-
understand.
Will be basically this will have an effect on the main.
I understand. That is why if you also desires, we can have it. no matter can also be
Yeah,
heard.
right in the eye,
If
right?
it could not be heard, then the eye may be.
Ah, so, and this is the matter, the eye also is it. As the state has submitted the written objection, this is the matter of the court. Already was directed in the earlier order that that paper book should be made. Already were directed.
Then let the eye remain. If it not be heard, then it can be.
No, but
Nice.
I think it's best
Yes.
if we are typing is heard because on the one part they are asking for acquittal. So it will amount to hearing the entire thing.
That is the reason I, in fact, submitted that we need to go through the evidence and which is in aspects. The one in the Gossip Justice was that in aspects, so I was thinking that it could be, but anyways, much of it.
The paper book has to be made lots of things. It's quite okay then, Manu. The registry was directed to prepare a paper book. No, they take time also. It is not the entire case in the Guwahati High Court. There are a lot of cases, lots of cases. They do it with you, right? Uh, the thing is that the IA had already been disposed of. He is behind the bar. So the expedient date for expedient hearing paper will be much. 2024 matter. You are watching that quite fast. That means you have heard part of your application. If supposing your application had been allowed, you would have no problem in the case of pending for another 10 years. Right. As paper book has not been prepared to lead, this is the matter of the police. Apologies. Yes,
Also, we are newly engaged in this paper.
newly engaged. So what to do if you're newly engaged? What are you going to do about it?
Deputy Krishna Gaurav. Will get it directly.
General file the written objection. Okay, Mr. R. Kaushik. Learned addition PP is granted for which time to file written objection to the application under section 430. Then in the main case, you write, paper book has been made. Copy has been furnished to you? No. Just show us the main case. Main case. Paper book has been furnished to Ismail Daimari. Paper book has been furnished upon learned additional public assignment, learned counsel on behalf of the applicant. Will take it. Ah, it is there. Madam, you take it from the earlier counsel. Miss
J. Simple.
J.
Simple.
Sing
PH.
PHO. Submits that she and her senior Mr.
And
M. Biswas will be appearing for the appellant and that they will be submitting their affidavit, their wakalatnama within
logical already find out.
and submit the wakalatnama has already been filed. Have you got the paper book with you? That Ms. J. Singh shall obtain the paper book from the earlier council in as much as the office note dated 20/2024 states that paper book has been furnished to the learned counsel on behalf of the appellant and also to the additional people. This is the matter. After COVID. People. Yes, any objection? Miss S. Khatane. Huh? Legal aid counsel submits that there is a delay of 49 days in filing the appeal against the conviction under section 302 IPC. Ms. R. Kaushik, Richard Picky submits that there was no objection to the delay in filing. Accordingly, the delay of 49 days condoned a registry to list the appeal. Verify it. Register the appeal and the I. And it's the same after a week. I is accordingly disposed. Item 12, item 48 system. Essential clause appears for the applicant and subject that there is a delay of 48 days in filing the appeal against the conviction and the section 6 of the POCSO. Now, Mr. R.R. Patil. Same thing. Mr. J.C. Bora. J.C. Bora, lawyer counsel for the applicant submits that there is a delay of 144 days in filing the appeal against the conviction under section 302 IP. Same thing, huh? If you will. They are appearing for this one. Any objection, 54 days only. Right, no one appears for the applicant. And Mr. N. Barwa appears for the respondent. This is an application for condoning the delay of 54 days against judgment and order dated 9/1/25 passed by the learned principal judge, family court, Act 1 in F. Civil bracket case number 1283 of 2021. Mr. N. Barwa submits that he has got no objection if the delay is condoned. Accordingly, the delay of 54 days condoned. Registry to list the appeal. After a week, copy has not been given. After a week, uh, the counsel for the applicant shall furnish a copy of the appeal petition to Mr. N. Barwa in the meter. I is accordingly disposed.
All the councils are not available.
Huh?
Councils are not available. 15 SC business, maybe some people were granted, appellants were given liberty on the juvenile, on the last period. Mr. J. Thomas counsel, clients.
So where are they? Huh?
Mr. P. Kotoki, these things also.
Each property is out of pages. Huh?
18.
Where is he? Huh? Out of station. Out of station for how long will he be out of station? Forever or for huh? Only for today. Then when do you want it? We are going to take if they don't come the next time, we'll appoint a magistrate cure and take it up. Maybe that doesn't mean that doesn't mean that the appeal should not be heard. You are appearing for whom, Mr. Constant?
16 and 17, you say.
You are appearing 16 and 17.
Mine 16 and 17.
16 and 17.
16 and 17.
Who is appearing for 15?
What?
Yes. Good.
Minimum fine and 25. You pay number 16.
They are all together how many accused persons, appellant, convicted persons? Seven.
Who would have, no.
Seven, I think.
Somewhere granted worship release on that for the juvenility.
No, that is all right. But I am asking how many
How many?
convicted persons are there in all? What to do with those persons who are juvenile? They will have to do. Can they?
Probably your lordship passed order.
Yes, where is the order?
Juvenile court procedure on her account. Lordship, 1/9/2025. Yeah, 1/9/25, we take something, but we can look at it.
That's in a different case.
Maybe I was the lordship of 1/9/2025. Konju Hare Krishna poema released on the ground in TV. 2 persons. Yes. But that's not your lordship, 1/9/2025.
What do you think we listed out of that? Yeah, like, we listed after some time, after some other, some agenda matter. The parents, the matter. Oh,
Lordship, can you have a look? Always there.
where?
It is criminal in 94, 2016.
Huh? One has been released on bail.
Yes, because ossification test was conducted. He was taken on our side, my lord, because it was done after 10, 20 years. Cannot be believed. The lordship, honorable court was pleased to release it.
They were released on bail.
Yeah.
So the issue is still is there any finality on the radius that has not been done? Has there been any finding made by this court with regard to the rate?
Yes. Lordship,
If there is a
a
finding,
perusal of a perusal of the ossification test report shows that the appellant Hare Krishna Paul and Sanju Paul and Porimal Paul were below 18 years of age on the date of offense. If the results of the ossification test cannot be precise except in a margin of error of plus or minus 2 years is to be taken into consideration. We have to lean towards the lower end of the range, that is towards juvenility, and the settled law that the view in favor of the accused should be taken. And the applicants Hare Krishna Paul, Sanju Paul, and Porimal had apparently been in judicial custody for more than 10 years. The said juvenile would have to be released from the judicial custody, even if they are found to be guilty of the crime in the present appeal in a case. The current case was referred.
so in that case, they have to go to the court.
Accordingly directed to be released from judicial custody, if not earlier released. That is as it as 3 persons. 3 convicts.
That's either 15 or either 15.
Yes, yes.
Either 15, they are all guilty. Correct. Okay, now only.
Lordship, Porimal is criminal appeal 94. Then Sonju criminal appeal 50. And Hare Krishna is 78.
So Hare Krishna is a juvenile.
Yes. Hare Krishna, Sonju, and Porimal. Sanju and juvenile. And Porimal.
Appeal number 78. Might not be actually juvenile, no, actually. Paul and
Hare Krishna, Sanju, Paul.
criminal appeal number 50, 50/2016.
50 is only before Paul.
No, one and one. Yeah, but people.
50.
Contour criminality 50. It's reflected in the order. 16. All the 17, there are two 50s. One
There are
50
two
oblique
50s.
17 and one is 50 oblique 16.
Where is 50 of it?
50 oblique 16 is gone.
Huh?
Gone, my lord, released on bail.
50 of 16.
On July.
Release of bail.
Release of a
Order separately.
ordered it in 1/9.
Okay, so those three are gone.
I know.
So that is Sanju in 80 of 16. In Sanju 50 of 2016. And Tera Parimal. Parimal is in 94.
94.
16 and
And Sanju 50, Hare Krishna 78.
so Hare Krishna can go. Hare Krishna is basically
Already released, my lord.
if he is already juvenile, then
Yes,
the
let us-
it's end of the matter. There's nothing to be done. And I think they have been in jail for how long? This Hare Krishna Paul has been in jail for how long? About 10 years. About
Yes, it is reflected.
one is in jail about 10 years. Okay, Hare Krishna Paul is gone. Okay, whatever. So well, so that we do not have we have to see. So whether we convict or do not convict or uphold the conviction, he have to be released. Now, in this 94 of 2016, there are three of them, and out of three, this Parimal Paul, again, he whether we convict or do not convict, he already undergone. So it's only for 2, 3, 4%. Yes, ma'am. The problem is how are we going to decide item 15 without the council? We have to hear the council. He's coming. He's coming. Correct. Who is going to argue? We have senior. Where is he? And and you are for item 15, 16, 17. Who is for item 18? Your senior is not here. Then we list it. Okay. All right. As Mr. P. Kataki, Direct Counsel for the Appellant in Criminal Appeal 50 of 2017. Is yes, what to do? Mr. Kataki is not here. He is what he's having his own client.
Other station.
Correct. He's having his own client, that much we know. But then all your cases are connected. You are all
Yes,
in one case. So we cannot dispose without his presence.
Mr.
Now the
Procedural.
problem is if we hear you three, then their holidays coming in between. They will forget.
I feel pity for Mr. Anam. Every time you ask, other person is a very tired the suffering.
What about?
Other doesn't get the submission for taking up the matter.
Has the paper book been done?
Yes, yes.
Yes, yes.
But your lawyer has granted. He has been.
Okay, well, let us hear. You know, what it is. Tell you. Bail. But then he
They're all ending. Except one person all around bail matter.
Nirmal Paul and Nirmal Paul is not on bail. So we are fighting for Nirmal Paul now.
Yes, sir.
He is inside the jail. All have been come out.
All have come out. All have come out.
Your lordship was standing up to them. 3 years or 4 have been declared juvenile. And one, your lordship father, 85 years old, your lordship they have completed 10 years inside the jail already.
The only Nirmal Paul is.
Nirmal Paul is inside.
You find an application for 3 years. Otherwise, we'll have to hear the entire thing. Okay, tell us.
Persons died, my lord, eyewitnesses account, injured eyewitnesses account, my lord, and specifically in these persons are lucky enough they are for the juvenility they were released. But their names is specifically and 34 your lordship.
Anyway, sometimes luck is there also.
Thank you, Lord. Kindness, my lord.
My mother, criminal appeal number 50. Nirmal Parliament.
So we will hear you. We will hear you. Okay, give us the tip.
Only saying that without the follow how.
Here it will not be short, but we are ready. Your friend is not ready.
I am ready, we are all ready. Only for property.
Kataki will hear him afterwards. Or what?
Next week, this bench is not available.
This next week, this bench is not available. Only the week after that.
Yeah. After holidays.
Please.
What we'll do is we'll fix first week of November. Huh? No. Acha. No. I will end of this October will be. Got it. 28 to 8.
Please. Please.
No, not as you please. You don't. Huh? No, this is 29. 29. Ah, 29. This you don't want to file bail application, so on the prayer of the party. This okay, right. The counsel for all the appellants are present except for the counsel for criminal appeal 50 of 2017.
Every council is absent,
Doesn't matter. Mr. Adjournment prayer has accordingly been made on behalf of Mr. P. Kataki. List the matter on 29/10/2025 for hearing. Okay, Master. P02. Any eyewitness? No eyewitness. Now what to do? There's no counsel. No one appears for the appellant. No one appears for the appellant. While the APP is present. In the interest of justice, let the matter again after 2 weeks. What to do? That matter we could have heard, but then again, 11:30, we could have heard that matter. That Mr. S.P. Biswasan. There were eyewitnesses, injured eyewitnesses.
The offensive technique is the fish marking. We present this easily.